Good morning. Hello. Good morning. My name is Shane Blundell. I'm work in the Attorney General's office. Seated to my right is Jocelyn Jones. On behalf of the Attorney General's office, thank you for coming to this public hearing. This is on the earned sick time regulations. That's 940 CMR 33. Thanks for your time and energy and your commitment to showing up today. We really appreciate it. Just kind of a brief overview. So an important part of making good law and good regulations is that we have an opportunity to hear the perspectives from all the people that could be affected by the proposed regulations. So we understand that there's a great deal of interest in this topic. Obviously, we have a packed house today. So we applaud that interest, your willingness to engage in this process. For us to understand, for the office to understand clearly the concerns you may have, to make us, we're going to ask, you may see us ask questions, trying to make sure we understand how the concerns that you are articulating to us are tied to the language of the proposed regulations. As you see us ask questions, if we do, please understand they have a specific purpose, to make sure that we can do our jobs in promulgating regulations that do address, or at least accommodate and acknowledge the concerns raised here. Just a little bit of information. So we obviously have microphones for myself and Jocelyn. There's a microphone up there. They are for amplification, but they're also recording today's hearing. So any comments that you make today will become part of the record for the hearings. So we just want people to be mindful of that. This is going to be recorded. And again, the recordings, as any written comments, will be subject to the public records law. We have, as I think many of you already seen, we have copies of the regulations themselves. We have some frequently asked questions. A bunch of information is out in the hallway. If you have any questions about that sort of material, you can also talk with Margie, who is right there, and Maddie Conroy. She's out in the back there, also helping out. If you want to submit written comments, we also have a couple of different ways to do that. We have an email address. It's agoregulations@state.ma.us. So if you don't want to testify today, you can also submit written comments via email. We've already gotten a great deal of comments through that venue. So happy to receive those. And we also have some more information about how to submit written comments. If you want to leave some written comments today, there's a box out in the back. I think what we're going to try and do, since we have a great deal of interest, we have the room till 1. What we'll probably do is take a break halfway through, but we're going to try and limit testimony to roughly 3 minutes. So we'll just let you know. And again, I think we thank you all for coming today. I just also want to acknowledge Dennis Jim Betty from Senator Spilka's office and the chair of the select board, Charlie Zazitsky. Thanks so much for letting us use this space. Thank you for the town of Framingham for being very generous with their time, again, and for having us access to this room. So I think what we are going to do is actually, I am going to take Dennis first. We do have a list of all the people that have signed in, so thank you so much for doing that. But we're going to call up first Dennis Jim Betty from Senator Spilka's office. Thank you.
Thank you very much. First, the Senator would like to express her thank you for coming out to Framingham and for choosing Framingham to hold your public hearing and for Metro West. And we're very pleased there was a good turnout here for this hearing. I do like to read a letter that she wrote into the record, if I could. It said, Dear Attorney General Healy, unfortunately, I'm unable to attend today's public hearing on the Attorney General's proposed regulations to implement the Earned Sick Time Law, but want to express my support of the Attorney General's proposed regulations. Earned sick time is an important issue that will help some of our most vulnerable workers in the Commonwealth. No one should have to choose between earning a day's wage and taking care of themselves or their child. We send a message that we as a Commonwealth value a healthy workforce that is productive, has better morale, and has a financial stability needed to support a strong economy. Almost 1/3 of our workforce stands to benefit from this act and its regulations. Given the amount of people that are relying on this act, I urge the Attorney General to promulgate regulations according to the current proposed timeline and permit the act to take effect July 1st, 2015, as required by statute. I'm also grateful to the Attorney General for her thoughtful safe haven provision, which recognizes the needs of employers who already provide earned sick time to their employees, but need some time to update their systems to fully to comply. The proposed regulations help clarify the Act and propose important guidance to employers on this implementation. I applaud the Attorney General for her hard work on these thoughtful regulations. Thank you. Signed, Senator Karen Spoka.
Thank you.
Debbie Tell.
My name is actually Debbie Toll, and I'm a small business owner in Massachusetts. We've provided vacation time, sick time, holiday pay since 1980. And I do believe in providing those things, but I also think that 40 hours is a great deal of time to have to pay for, as a, coming from the standpoint of a small business owner who is competing with people who work under the table and hire under the table, and there never seems to be any recourse for a company like myself. I also have, I'm not sure I would call it a concern, but I'm kind of questioning why on earth we would allow anybody to accrue time at a rate that they cannot use. So given the formula, it looks like you can accrue, 69 days? If it's 1 hour every 30, or is it 69 hours rather, I'm sorry.
40 hours.
No, but 1 hour every 30 hours you work.
It gets capped at 40.
Correct. But why not use a formula that reaches, that you accrue exactly 40 hours within 1 year? Do you understand?
It was in the statute.
Yeah. It just seems ridiculous to me, So that's one of my concerns. The bookkeeping is a concern. And the fact that a lot of these laws don't line up with each other. The Family Medical Leave Act, we're using 50 employees. Health insurance, I believe, certain regulations, you have to be a company that's got 50 employees. There's another program in here. I noticed you only have to have 6 employees or more than 6 employees. Why is 11 or 10 or 20 or 50? Why don't any of these programs line up? It's a huge bookkeeping task for small companies. And to have to bookkeep for 5, 6, 7, 8 different numbers is really silly, in my opinion. So again, my concerns are, why are we accruing so rapidly? Why not make it cap? Why not accrue so you end up with 40 hours at the end of the year? And my other concern is, who is going to help the small business owner who complies and is competing against the small business who doesn't, particularly small businesses that are under the table? Where can we turn? Who can we report them to? What will happen?
The Attorney General's office.
And what will happen?
We have enforcement power under the law. So if you have complaints, whether you know of employees who are being who are not getting their earned sick time or any kind of violations, you can report them to Fair Labor Division of the Attorney General's office.
Okay.
Thank you.
Yep. All right. Thank you for your time.
You're welcome. Thank you. Okay. Lisa Gurnier.
Thank you.
Morning.
Hi, my name is Lisa Gergoni. I'm with the Home Care Aid Council. We represent about 140 home care agencies in Massachusetts. We were a nonprofit association started in 1967 to work with elder affairs to develop standards of best practices and policies to support home care workers, providing care to elders and disabled individuals living at home. So our service is really aligned with the Providers Council. I know they presented a lot of testimony to you people, to the Attorney General's office related to this. And I echo their concerns, but I won't repeat them. I just wanted to express our concern from the home care aid workforce. Similar to the Providers Council, we have a number of part-time workers. And really that is because of the authorizations we receive from the state and consumers. They need someone to help their mom 2 hours a day, 3 times a week. So we have part-time workers. We're very concerned about the 24-hour consecutive work hour provision because for some of these workers, that would take 12 days to get to 24 hours before they would have to give notice. And when these workers are sick, they are leaving an elder or a disabled individual who needs care home alone. The agency has to scramble to find someone to replace them. There's concern. A lot of these workers work for multiple agencies. Again, because of the authorizations, they have to piece together a lot. Our council really supports workers. I am at the State House all the time. Yesterday I was there trying to get money for them and a wage pass-through. We have done lots with earned sick time, support health insurance, but there's just so many variables that really make this, unfortunately, a part-time workforce. And systematically, the state has to look at that. I've been working with Elder Affairs on that. We're trying to find solutions. But there are a lot of barriers for these workers that it's difficult. The 24-hour calendar time period is tough because these workers often leave. A lot of them are immigrants. They go home for 6 months to another country. They come back. The nightmare of trying to manage that and kind of calculate that in the agency, it's going to add a huge burden to a system that, again, is not really a funded it's unfunded mandate. They're not going to get reimbursed on their rates for those things. The other issue of working with multiple agencies, you could have a situation where a worker works for 3 agencies. One calls and says, my worker called out, so can you come care for Mrs. Jones? We'll give you a bonus. So then she calls out to the other agency. And now this Mrs. Smith has no care that day, and that agency is struggling. So it's really very complicated in this industry, the part-time nature. And the blended rate is also an issue because you're saying in your regulations, I think, that it's going to be based on the previous work week. And as I just explained, every work week is different. Every pay period is different for these workers, which is a huge problem. I totally agree with. But, so now that company has to decide, okay, she's sick today. What was she paid last week? What's her rate this week? It's very complicated, very convoluted. So we're concerned about a lot of things. We've been working on it for a long time. And we just feel like that part-time piece is really tough. And the quality of care issue, very concerned about how this is going to impact all those consumers at home, and how it will play out. So that's kind of our concern. I will put them in writing at some point, but I do echo what the Providers Council said as well.
Thank you very much. You're welcome. Dennis, Dennis already spoke. Daphne Fallon. Is that Daphne? Yeah, she's got that.
Good morning.
Good morning.
My name is Daphne Phelan. I'm with the Davis Companies. I'm a Human Resource Director for them. Let me first say thank you very much for holding these hearings and listening to our concerns. We are in support of the law and will implement for July 1, but we do have some significant challenges that face our company. We are a large temporary staffing firm. We've been headquartered here in the Commonwealth for 30 years, and we place predominantly skilled manufacturing, engineering, IT positions. Staffing agencies such as mine do play a critical role in the economy here. Last year alone, we employed 260,000 workers, not my company, but as an industry. So we are a significant piece of the Massachusetts workforce. Today we have 4 proposals for consideration. The first is the break-in service, which we just heard spoken about, but the proposed regulations allow the workers to maintain the right to use the accrued earned sick time after a break-in service of up to a year. We recognize that our workers come and go from assignments and that some reasonable break is necessary. But we would like to propose that the final regulations adopt the break-in service similar to the Affordable Care Act that's already in place. Again, adding to some consistency, get some laws in line with one another. And to be honest, every company should be able to track and be in compliance with that already. That would certainly reduce the burden. Secondly, we ask for further review on the hours worked outside the Commonwealth. The regulations state that an employee should accrue time on all hours worked, even when they're outside Massachusetts, so long as the primary place of business is Massachusetts. So I offer this scenario for consideration. We place workers all over New England. So if I place somebody in New Hampshire, they do not have a law similar to this. They work 90 days in New Hampshire. Those hours are not tracked for purposes of Massachusetts paid sick time. But then what if that worker now switches assignments and works 91 days in Massachusetts? Do I then need to go back and retroactively accrue because their primary place of business has now shifted to be Massachusetts? And what is my burden with that? How do I possibly comply with that when I place, Massachusetts is very small and we have lots of border states that we place people in. And what happens on the flip side of that when somebody has worked 90 days in Massachusetts but then works 91 outside Massachusetts? Do they lose that accrual? The third point is that staffing firms commonly know when employees are going to end their work with us or end an assignment, which is kind of unique to us because we talk to our people about that. And we do that proactively so that we can place them in their next assignment and prevent them from having gaps in employment. The proposed regulations permit the worker to take up to 3 days of paid time off without giving notice before ending the relationship with the staffing firm. We're worried that this could lead staffing firms to stop giving their employees notice of their assignment ending for fear that they would just take the last Wednesday, Thursday, Friday off knowing that they don't have to provide documentation for that. So we're asking that under this specific circumstance, we respectfully would request that sick time taken within the last week of an assignment should be treated as unpaid leave until the employee produces the appropriate medical documentation. And lastly, companies use agencies like mine to augment their staffing models during critical times of need, and it's very common for us to see a big spike in business over the holidays. The proposed regulations allow workers to take that same 24 hours of paid sick time without supporting validation of an illness. We recognize fully that people get sick over the holidays. It happens. And we're not asking for a blackout period at all around the holidays. We're just saying that in the event that sick time absence occurs the day before a holiday or after a holiday, we would like the opportunity to require documentation of a medical illness at that point. Out of respect for the time and any other recommendations that we have will be submitted in writing, and I thank you for your consideration.
Thank you very much.
Thanks.
Mark Terry.
Good morning. Thank you again for being here. My name is Mark Terry. I'm a partner at the Labor Employment and Employee Benefits Group at Myrick O'Connell in Westboro. I also serve as the chair of the Public Policy Committee of the Metro West Chamber of Commerce. Although the Chamber did oppose the law because of the burden it put on small businesses from an administrative perspective and a financial perspective, the Chamber accepts that the law is in place and the comments are offered at this point in time in an effort to use the regulations to try to balance the rights that are afforded under the statute to employees with the concerns of businesses, particularly small businesses. I do have a number of comments, and I will submit them in writing, and I'll try to get to the chase with each of them because there are a number of them.
Are you submitting these on behalf of the Chamber?
I'm submitting them as an individual involved with the Chamber.
Okay.
The Chamber has not officially ratified this, although the Chamber position has been opposed to the law generally.
Okay. Thank you.
So I want to start with, I think, three provisions that are positive, and I don't want them to get lost because down the road somebody else may offer comments adverse to them. But from the perspective of business, I think there are three things that are in these regs that are really important. One of those is that it clarifies that the purpose of the law and the way this is supposed to be applied is to make sure people have access to time, paid time. And I think there was a real significant concern upon the first reading of the statute that it was going to mandate the creation of an additional 5 days of leave. I think what the regulations do, which is very helpful to companies right now, is to say, look, if you're offering people 20 days of vacation days or vacation or 10 of vacation, as long as they can use it for sick, then that's good. And I think that's a real positive step, one that the business would certainly support. The second thing that I think is helpful in there is that there are clarifications about what it means to provide more generous benefits. That, too, was a point of concern for business, where people were asking questions like, well, if I just gave 40 hours of sick leave on January 1st and they had this whole accrual mechanism, was that okay? So I think business certainly supports that as well. And the third thing is the preservation of the good attendance bonuses. There was significant concern about whether not providing a bonus would somehow be a retaliatory act, and certainly clarification, again, is something business would support. I want to highlight the other points of concern, some of which have been touched upon already. One is in Section 3301, the statute says this is in addition to leave that is provided under the FMLA and assorted other statutes. And that really raises a big concern, I think, when you come to administering and implementing the law, because it's not clear whether that's intended to be 5 additional days that are not covered at all by these other statutes.
We will be clarifying that further and making clear that it runs concurrently, except in certain circumstances where the use is not under the Small Necessities Leave Act. As you know, there are instances in which you can utilize the Small Necessities Leave Act that have nothing to do with sickness, and we'll be clarifying that. But for purposes of this conversation, know that the FMLA, et cetera, run concurrently.
Okay, and fantastic. That's exactly what we were looking for.
And therefore allow an employee to have, if the employee gets paid sick time through the law and is taking FMLA unpaid, there's payment there for the employee.
And that's exactly what we were looking for, so
Great.
Thank you. The other thing that I'd point out, and this is more of a technical issue, is there are a number of references in the statute to the payment, the method of payment, the amount of payment not being less than the minimum wage, and there's a statutory reference. We're certainly not suggesting that the payment be less than minimum wage, but recognize there are some employers that are covered by this law that are not covered by the state minimum wage, they're covered by the federal minimum wage, and we wouldn't want to see a point of confusion created there by reference to the specific statute.
Thank you. That's a great point.
The other thing that comes up, and this is a practice I have in public sector entities, the statute, as you know, references cities and towns. Mm-hmm. Most statutes refer to political subdivisions and look at, for example, regional school districts on the same terms as cities and towns. Mm-hmm. I suspect that this was an issue in drafting, and who it was that prepared the act and pursued it probably didn't recognize that definition or that distinction, but it does seem appropriate in the regulations to clarify, perhaps, that for the purposes of these regs in the law, cities and towns include regional entities that are made up of cities and towns. Right now we have a lot of regional school districts that are sitting out there saying, does this apply to me, or am I part of the local acceptance provision like cities and towns are? One of the things that also concerns me, I think, from an administrative perspective, is there is provision here that allows an employer and employee to agree that employee could make up time later in the week or in the same pay period. Overtime laws are all weekly, and what I worry about is if the employer, in an effort to work with its employee, says, no problem, you don't want to use that paid sick leave and you want to save for next week, well, make up the time next week. Well, that does have a potential overtime liability to the company, and I think there are a lot of small employers in particular who probably wouldn't recognize that. So I think it probably makes sense, although more limiting on the parties, to restrict that to things that occur within the same week. So you can do the same kind of schedule adjustments without it impacting sick leave, but I think it ought to be limited to that 1 week, or I think you're going to have a lot of disputes on your hands that can be avoided and aren't necessary.
I think that is, would have to be a statutory change because it's actually in the language of the statute itself.
Okay. And then perhaps the regs would point out that there's an overtime liability so that people would become aware of that.
I think they do. Okay. I think that is part of the, I think there's I do believe, it's either in the regs or in the fact sheet. But we'll point it out. Do you want to check with that? And
I'm not beyond missing the details in this stuff either. I've read it a lot fewer times than you have.
Hey, thank you.
The next point is one of administration. It's a real concern around the sick leave notes provision. There are really two concerns there. One is the provision that allows a person without a health care provider to provide their own note. Mm-hmm. I think that is a real concern. One of the biggest reasons for business to oppose this is the concern about abuse. And if an employee is not able to provide a note from their doctor or a doctor and comes in and says, here's my note, and they sign it themselves just saying, yes, I swear I was sick, that just really opens up a can of worms, I think, for employers. And there is, of course, no way for an employer to verify the person has a medical provider or they don't. That's one concern there. The other is that when we're talking about these 24 hours that have to be used, there are circumstances in which that time can also carry over into FMLA entitlements, because the FMLA incapacity period is based on the 3 consecutive days of incapacity rather than 3 days of absence. And so you put employers in a position where if they comply with this statute, they're out of compliance with the FMLA. I think a simple amendment to the regs that said, unless otherwise permitted by state or federal law, takes care of that problem and allows people to comply with both laws.
Okay.
And the last point that I'll make, and there are more details in my written submission, but is this provision about the definition of a healthcare provider. It's broad, and we're not taking issue with the breadth of it. But there's nothing here that says somebody couldn't show up with a note from their doctor as the healthcare provider, their dentist as a healthcare provider when they've been out for gallbladder surgery or something like that. So there ought to be some requirement that the healthcare provider who provides a note is actually somebody qualified to treat the person for the condition they have. Okay. I want to thank you again for the time. I will submit these to you in writing, and you did ask me before to submit them electronically, which I will do. Thank you
very much. Rick Ciccarelli.
Thank you. My name is Rick Ciccarelli. Question, these meetings, the law takes effect in July, is that correct?
July 1st, that's
First.
correct. Right.
And so these meetings here, are they going to be able to amend this law that's taking effect July 1st?
Yes, I mean, we're taking comments from the public for purposes of informing potential revisions to the proposed regulations.
Right. I have a concern about, the number of employees, 11. If you have 11 employees, again, where these numbers come from, and why they're not consistent with other things, like one of the other speakers had said. As a small business owner, 11, is just a small number. Right. The number should be larger.
Right. It's actually in the statute, so there's nothing we can do by way of amendment.
We can't. It's in the statute, but why those things can't? All these other things we're talking about. Why can't we change that number?
Because it's actually in the statute.
So how do we change it?
It would have to be a legislative amendment.
Okay, so that's a step that needs to be taken, because 11 is just not fair. So if I do that, that means I need to go to my state rep or my state senator to try to get something changed.
Yes, only the legislature can change it.
And so none of these numbers that they came up with, there was no public comment. They just came up with them whenever they wanted to, correct?
It was actually, the law was voted on by the public in
But it didn't say 11. Did it say 11 employees?
It said 11, yeah.
But there was no way to change that other than if we voted it down.
That's
okay.
That's
okay,
correct.
So I'll work on that. It seems like there's been a real, when it's become a burden to be an employer in Massachusetts, this, that, and the other thing. It's a little tough. Time and a half on Sundays. Time and a half on Sundays, which goes back to the blue laws. I tried to get that changed. I spoke to my state rep, and it wasn't too keen. Oh, you can't take away something that's already been given. Well, I know that has nothing to do with this, but it just keeps more and more things keep happening to small businesses, and it's hard for us to keep up. This whole bookkeeping thing, that's going to be hard. If I don't have an HR department, I don't have a full-time bookkeeper that does, we do a lot of this ourselves. So it's just a real burden, and I just don't know when the next vote is going to come up statewide to hurt us again. Anytime you put a vote up to the public, that's going to put something in their pocket. They don't care where it's coming from, their employer or the state, they're going to vote for it. So it just seems to keep putting a burden on us as a small business. And again, it's just too bad that they don't look as a small employer. 11 is considered, I would say, a small employer, and it's really hard for us. So the number should be, who knows what, but not what it is as now, which again can't be changed. So we're disappointed, but that's all. Thank you.
Thank you very much for your time. Okay. Kate Main Roycroft.
Sorry, my handwriting's really messy. It's Kate Marie.
Okay, Kate Marie.
Thank you for allowing me to testify. I'm the Director of Public Policy for the Alliance of Massachusetts YMCAs. The YMCAs in Massachusetts have 31 corporate associations. We have 82 branches and 377 service locations. We employ 16,000 full and part-time employees, and 2,000 of which are youth. Last year we served 370,000 youth, and we served 1 in 5 residents in the Commonwealth. So thank you for this opportunity to testify on the Earned Sick Time draft regulations. The YMCAs appreciate the balanced approach that your office took in producing these, and we're asking for clarification and some changes to a few of the regulations. Our first and major concern with the regulations is around the break in service section. We are currently reading these draft regulations that if an employee has a break in service for less than a year, that they can use the accrued sick time from before their break in service and can continue to earn paid sick time from their first date of employment. This will be problematic for our YMCA summer camps and camps. Our YMCA camps employ many teens and young adults as seasonal employees, both summer and winter camps. These employees do not stay employees of the YMCA throughout the entire year, but rather when they are employed as a seasonal camp staff. So if a camp staff is employed to work for 3 months during the summer and 2 months over the winter, they will begin to accrue paid sick time and will be able to use that during the next summer. We are very concerned that this could lead to our teen staff misusing this time off policy. We're also very concerned about the amount of administrative work that this is going to be required. Our request is that this section be removed from the regulations as this language was not part of the statute. If that is not possible, we are asking for an exemption for seasonal employees. Secondly, your office has ensured us that Section 19, Alternatives to the Use of Earned Sick Time, an employer and an employee by mutual agreement may arrange for the employee to work additional hours during the same or next pay period to avoid the use and payment of earned sick time. That this means by mutual consent, employees are allowed to swap shifts. If one employee needs to take time off for a doctor's appointment, they can swap shifts with another employee, avoiding the use of earned sick time. We're just asking that this be included in the regulations for clarification, so an example would be helpful. Finally, we do understand that the notification requirements are specified in the statute that passed. We would like to voice our concern that the lack of notification requirements will cause problems for our Ys, especially those who run residential programs. For an employer having to find someone last minute to cover the second or third shift, the evening and the night shift, if an employee does not give adequate notice, will cause many problems, and in some cases, we will violate staffing laws. Thank you again for your work on the draft regulations. I look forward to continuing to work with you guys.
Okay. Thank you. If you want to. Representative Dykema, would you like to testify? Was you coming? Okay. Okay.
Thank you very much. It's a full house. It was challenging
We
to
do
get
have a
up
full
here.
house.
I will not speak for long. I just wanted to thank you for coming out and recognizing the needs of Metro West and the importance of getting feedback on this ballot initiative that was voted. I have been receiving some concerns from our small business community about the details related to the implementation of this and the challenges regarding that. I recognize that you're being as flexible as you can be, and I certainly appreciate that. I've encouraged them to come here and express specific concerns themselves, but I stand willing as a legislator to continue to work with you to make this transition as easy as possible. So thank you very much.
Great. Thank you very much, Representative. Corey Higgins.
Thank you both for coming out. My name is Corey Higgins. I'm of counsel with the law firm of Myrick O'Connell, Damali, and Luigi in its Labor, Employment, and Employee Benefits Group. And I have a few questions that have been raised by employers in the Commonwealth relative to the proposed regulations. So the first one, I think it's just a point of clarification. How is sick time accrual calculated, or how would it be calculated, where an employer has an already existing policy that provides that time off counts as hours worked for the purposes of calculating overtime? I interpret the law to mean that it's only hours actually worked that would count towards the accrual, 1 hour for every 30 hours worked. But some concerns that employers have is if you count vacation or other time off towards overtime, that this would somehow be construed as requiring that same interpretation in the accrual for sick time purposes. The second question is, are municipal agencies or municipal instrumentalities, which is defined or interpreted under the state ethics law, for example, are they subject to the local acceptance provisions of the new law? The new law is drafted in such a way that it only defines cities and towns as being subject to local acceptance. But if you had, for example, a housing authority or a regional district, those are treated as municipal employees in other contexts. So for consistency's sake, we would request that there be an interpretation that would require local acceptance for those entities as well. In terms of not being able to require any documentation to explain the nature of the illness under Section 33.06, subsection 5 of the proposed regulation, how would this be reconciled with the medical certification that is required in certain situations under the Family and Medical Leave Act? Also, how would situations under the Americans with Disabilities Act or Mass General Laws Chapter 151B, which is the state anti-discrimination law, where you had an employer who's engaging in what's called the interactive process, working with an employee to determine whether they need a reasonable accommodation. Let's say it's in the context of leave. In those scenarios, under those laws, an employer may ask for medical documentation to support the need for that accommodation. How is that going to be reconciled with the limitation in the proposed reg as to what information may be included in the sick time note from a healthcare provider? Because you may have some overlap in those situations, and there's concern about preemption in that context, both in the FMLA and under state and federal anti-discrimination laws. Is there any attention that's going to be given to waiting periods where you have a short-term disability policy, and before that kicks in, how sick time would be administered, or would it just remain consistent under the
Can you explain
regs?
that? So
in some short-term disability policies, there's a waiting period before you would apply the STD benefits. In some cases, employers are requiring employees to use any accrued time off that they would have or accrued sick time. I don't think that would change, but we've gotten a couple questions in that vein and just want to see if there's any thought given to...
Yeah, when you say, can you just explain a little further, when you say waiting time, are you talking
like
about...
5 days or 10 days before the policy will be triggered, payments under the policy?
5 days of what, absences?
Correct.
Okay.
And for a qualifying purpose. Mm-hmm. So there would presumably be some overlap between a disability, short-term disability, and the purpose of the new sick time law. Mm-hmm. In terms of the safe harbor regulations, can an employer with the policy as of May 1, 2015, simply add employees that were not previously covered and still enjoy the safe harbor for all employees? Or would the employer in such a case need to have two separate policies, one that covers the existing policy that covers employees that would be subject to the safe harbor, mm-hmm. and then a new separate policy for those that aren't, that would have to be rolled out effective July 1? Or can you do it either way?
Just because this is something that was announced after the regulations, I just would like to address that. And to be clear, if you have a policy in effect that applies to some but not all employees in your employ, and you want to take advantage of the safe harbor provision, you would have to extend the coverage to the remaining employees, and then you would be covered. Then you would be covered by the safe harbor provision.
Okay. And in that context, if you have other provisions in the existing policy that aren't in compliance with the law or the proposed regulations, Would you just need to administer it in such a way as to bring it into compliance during the safe harbor period, and then as of January 1, have a policy that is consistent with the express provisions of the regulations and the law?
Right.
Okay. In the calculation of the base rate, under the definition of same hourly rate, in section 33.02 of the proposed regulations, are stipends, shift differentials, and longevity payments included in the base rate? There's some conflicting provisions. One says any benefit that can be administered on an hourly basis, and then later on there's exclusionary language that says premium rates aren't covered. So I think you could have a shift differential that's on an hourly basis, and that would be tacked onto the base rate, but then that could also be deemed a premium rate. So it's inconsistent and somewhat confusing. Likewise, are weekend differentials considered hourly benefits to be added to the base rate wages, or are they premium rates under the exception? In the context of the cash out that's permitted in section 33.03 subsection 22 of the proposed regulations, would it be permissible for employers to permit employees to convert some amount of accrued unused earned sick time to some other form of earned paid time off, such as vacation? It's not quite a cash out, but it's a conversion to be used later at the end of a calendar year. Is that something that the Attorney General could consider in building into the regulations? Because some employers would like to be able to do that. Is it okay for employers to require employees who are absent for a covered purpose under the sick time law to actually use any accrued unused paid sick time to cover the absence? I think it's implicit in the law, but it's unclear whether it's the employee can elect to have paid time or not paid time. I would recommend that it be required, or an employer may require, to the extent employees out on a covered purpose, if they have accrued unused sick time, that they be required to use it. And lastly, for employees who are paid fees for service, such as teaching a class, how is their hourly rate calculated if the amount of time would differ from week to week? Is it akin to a piece rate scenario that's contemplated in item 2 of the same hourly rate portion of section 33.02, where you would look to the prior, I think it's pay period, to come up with a calculation? That's sort of just unclear.
And when you ask that question, is it a situation where the employer doesn't take into consideration preparation for a class?
I think that you could certainly consider that, but I don't know specifically, but I think that would be helpful as well, if that would be built in, if that's part of how they're paid.
I'm just asking in terms
Sure.
of other things, that other ways that an employee might be paid in that context. Are they getting unemployment? Are the hours that are used for preparation for a class included in what's covered?
I would think they would be compensable in that scenario.
Okay. Thank you very much.
Thank you for your time. Thank you.
Chris Walsh, please.
Hi. Thank you. Chris Walsh, a state representative from Framingham. I'm going to be very brief because I have to get into the State House. I'm in favor of this. I do know, and I've talked to a number of constituents in terms, particularly people in restaurant business, small businesses. They're very concerned about the amount of paperwork and just the ability to handle this. I think that if I look at the larger scope of where we're going, this employees in Massachusetts are very, very valuable commodity. We're sort of known for our educated workforce. This is, I think, in the long term going to help us be able to attract employees into this area. On the other hand, we have a situation where a good 80% of our jobs and companies are actually small businesses. So I think this has to be very carefully weighed with the kinds of mandates put on people, just in terms of making it as simple and straightforward, easy to do as possible. So overall, I think it's a really good place to go, but I would just always caution just to think about this in being able to streamline it, particularly for those smaller businesses. So thank you very much, and always willing to, as Representative Dykema said, work with you all on this. I think it's a great bill. Thank you.
Thank you very much. Vladimir Zarkum. Do you have an extra piece of paper?
Hello, my name is Vladimir Zarkin. I'm an owner of Right at Home in-home care and assistance out of Newton. And we are a member of Mass Council. You've heard testimony of Lisa Gargoni earlier on. And I would like to echo her testimony and testimony of other people who are employers of variable hours employees. But I would like, first of all, to consider this law in the larger context of year 2015 in which we are. We have in Massachusetts right now, obviously, federal mandate for Affordable Care Act, as well as minimum wage increase. So, and I think it would be fair to consider sick time, proposed sick time law, together with other mandates which are imposed on small and medium-sized employees. So having said that, I acknowledge that Massachusetts voted, so there is no way back. However, as far as implementation, I understand that you are proposing a rollover, half a year rollover, but as far as implementation, I think to clear everything, to accept all comments, I think I would suggest that Attorney General motions to postpone implementation until January 2016. I think that's going to be very important for everybody here. Not to rush. Another thing is, and again, I'm probably going to be echoing others, again, variable hour employees. With other two mandates considered, ACA and minimum wage, we already see significant burden being placed on us, not only in terms of direct overhead, but administratively. Our vendors are not necessarily prepared to handle it. We deal with payroll companies, we deal with people who advise us on legal matters. They are not ready. So what I would like to make sure that is being understood, that at every clarification which is being made from Attorney General office requires hours, if not days and months, well actually it requires months sometimes, of implementation of those clarifications, including software and other technical matters. So please consider it when you establish implementation guidelines and compliance guidelines, because otherwise it just opens a can of worms. And again, our industry, home care industry, is a variable hour employee industry comprised mostly of people who work for many different agencies at the same time. So again, just to echo sentiment of other people, that opens a can of worms, that opens potential for abuse. And I think what this law currently is trying to do is to combine sick time. I think it's not even fair to call it sick time, because in reality it combines mandatory PTO time, because when an employee is absent less than 24 hours, they are not required to produce any documentation. Even if they are more than 24 hours absent, that still cannot be condition of non-payment. So again, that's not really a sick time per se. This is paid time off, and if it is paid time off, then employees have to be compliant with our policies of paid time off. They have to give a proper warning unless it's an emergency. So again, all this has to be considered, in my opinion, before this law takes into effect.
Thank you very much.
Thank you.
Marcia Galvin.
Good morning.
Good morning.
My name is Marcia Galvin, and my family owns and operates Normandy Farms Campground in Foxborough, Massachusetts. And in 1759, our family acquired the land in Foxborough, starting a working farm. And in 1971, we went from farming to develop a campground. We're now on our 9th generation of family that works the land, and we have 450 RV campsites. We have about 100 acres of land, and we employ approximately 100 part-time seasonal employees. We're open 8 months of the year. So we have 20 employees that we do have generous benefits for that work for us full-time. But my concern and my family's concern are the 100 seasonal employees that we have. We have mostly high school and college-age kids that come to work for us starting in April on weekends. The 10-week summer season, they're here with us full-time, and then they work the weekends in the shoulder season. And for 24 hours, for the break of service, they basically work 1 day a weekend when they're home from school or between sports. Most of the teens that work for us, it's their first job. We employ 14-year-olds all the way up, through college. And it's a burden for us to have to allow these teenagers to be able to take sick time. Now, the intent of the law is to be able to have time when you're sick, when your spouse is sick, your dependent children, your in-laws, your parents. But the teenagers are more focused on maybe going to the beach, and rather than taking care of their parent when the parents are sick. And since we have, we're in the hospitality business, if we have a group of, high school kids that would like to go to the beach the next day, and they all work in our pool complex, we have 4 pools, it puts the safety of our guests at risk, because we don't have a huge pool, if you say, of seasonal employees to choose from. We have our set employees, and they have specific duties that they need to fulfill. On behalf of the Campground Association, I'm also president of our Massachusetts Association of Campground Owners. We have 70 parks that have the same concern across the Commonwealth. We're key for tourism. I have a seat on MOT, on the ACT&T. So collectively, campgrounds really do have a concern over the seasonality and part-time students that we have. And we would like to see some sort of consideration given for those students that work for us, that don't really need the intent of the law for themselves. Maybe a provision be made for that.
Thank you very much.
Thank you.
Okay. Carmine Gentile.
Good morning. My name is Carmen Gentile. I'm a state representative. I represent Precinct 3 in Framingham and Wayland, Sudbury, and parts of Marlborough. And thank you for coming today. There are a number of my constituents who've contacted me on this. I think it's a good law. We need to empower our employees with earned sick time so they can take time off for the reasons articulated in the statute. I do want to raise a couple of concerns, and one is, or questions. On the same hourly rate definition, it talks about an employee compensated on an hourly basis. The same hourly rate means base rate, wages, and any other benefits paid or accrued on an hourly basis if the individual works. It goes on. It talks about calculating a blended rate on the basis of the prior pay period. However, I didn't see prior pay period defined in this. Is prior pay period the prior month, the prior week, the prior? If the employer normally pays on a weekly basis, or every 2 weeks, or monthly, is that the prior? Is that how? Would that be the prior pay period?
Right. I mean, that definition is borrowed from the wage and hour laws existing regular hourly rate definition, and under the law there are different rates at which employees can be paid based on their status, weekly or biweekly, and then monthly for certain executives, et cetera. So the pay period is whatever the pay period is,
as defined in the other statute.
Right, but as restricted by the law, but as paid by the employer. So if the employer wants to have a weekly pay period, it's a weekly pay period. 2 weeks is the general rule is 6 days before by the end. An employee has to be paid within 6 days of the end of the pay period. The pay period is a defined regular period of time.
So employers, restaurateurs have wait staff. Now the wait staff are paid the not the normal minimum wage, but that waitstaff wage, which is unfortunately substantially lower. So the calculation of their compensation for purposes of hourly rate, does it take into consideration the tips that they would normally make and do make during a shift?
Under the tips law, an employer can pay the service rate as long as the tips make up the difference between the what is now $3 service rate and the $9 minimum wage. So the employer is always responsible for making up the difference between the service rate and the minimum wage if the state minimum wage if the tips don't make the difference up. In this case, there would be no tips because the employee wouldn't be working, so the entire minimum wage would have to be paid for service workers.
So I would think that there are many employees who would normally earn in excess of minimum wage because if they're getting good tips. So would the and those tips would go into calculation of their prior pay period, so that they would be compensated at that higher rate?
The tips are not included in what's required by law. Tips are tips. They're not. The minimum wage is what the employers must pay unless they set a higher hourly rate for the employees.
Okay. So in other words, a waitstaff person who earns sick time, when they need to take that sick time, it would be based on
no less than the minimum wage.
And And is it correct to say that it wouldn't, from what you've said, that it wouldn't be based on a figure higher than the minimum wage?
If the employer has set a higher than minimum wage hourly rate for the employees, which is absolutely possible. Then it would be the higher wage. But if they have not, then it would be the minimum wage.
So if a waitstaff person is making $25 an hour based on because of their tips, and they take a sick day, they'll be compensated since.
They'll be compensated unless the employer has set a higher rate. They would be
at
compensated
the $9
at $9 an hour.
At the minimum wage.
Yep.
I see. All right. Well, I want to thank you for conducting these hearings. So, a number of constituent small business owners have contacted myself and other representatives and senators with the concern that they need the regulations there needs to be some finality before July 1st so that they can have whoever does the bookkeeping and the software writing done so that they can keep track of things.
They'll be published on our website on June 19th. They don't get officially filed by the Secretary of State until July 3rd, but everyone will be able to see them June 19th.
And also, I think one concern many of us have are for the very small business owners, people that might just have 12 or 13, 14 employees, that it will be more difficult for them to keep track of things and do what they need to do than for larger employers that have better cash flow or have more resources. And I'm thinking that it might be helpful. It might be helpful if we put together something that could address those needs, or almost like a template, put together some type of a template for them to use that would make life easier for them, less expensive to implement the law. I mean, we could do something at the state level that people could use and wouldn't have to, it'd be a large saving, I would think.
Thank you.
Thank you very much.
Yeah, and just so you know, the next number of months are going to be where we are really focused on ensuring employers understand the law, so that it becomes secondhand, and it will be largely focused on education and outreach, and questions that come up over the course of those months will be addressed, and we really appreciate you coming to share your concerns with us.
I'm going to stay and listen to some more of the.
Thank you very much.
Thank you.
Okay, Joanne Thompson. They're all done.
morning.
Good morning.
Thank you for this opportunity. I want to speak very specifically about this law and my particular small business, which is a taxi cab company, a little unusual. I own and operate Tommy's Taxi, based in Framingham. We serve the greater Metro West region. We were founded in 1946 by my dad. We are a second-generation business. We employ between about 45 and 55 drivers, somewhat seasonal. Our drivers, oddly enough, are employees. As you may be aware, most cab drivers in the universe are independent contractors. We have always maintained that we can have a more stable workforce and a more responsive to our customer demand workforce by having employees. And corollary to that is that we have offered health insurance since long before the Affordable Care Act, half company paid dental insurance. We offer short-term disability and life insurance, and we offer a simple IRA with a 3% match. These are benefits extended to our full-time employees. This new law is going to be extremely burdensome financially and also extremely burdensome and unwieldy in terms of record keeping for my company. Managing the tracking of cab drivers is, at best, on the best day, it's a difficult process. Matching driver scheduling to customer demand is half science, half art. A rainy day, a graduation, a big local wedding, all of those things can impact our business. Drivers calling out sick, for whatever reason, calling out, reduces my pool of drivers to serve my customers. I try to call other people in. My expectation is that under this law, I'm going to have spare drivers on duty. My drivers are commission-based, period. There's no base wage. They earn 40% commission plus their tips. Extra drivers dilutes the earning capacity for everyone working that day. And I see that as a real concern. Because 2 more drivers on staff out of 20 means everyone's going to book a little bit less that day and sit a little bit more. I think there's a high potential of abuse in this law. My drivers do not punch in now. They have assigned shifts. Sometimes if they know it's going to be a slow day, it's a nice sunny day, it's the middle of the month, it's okay to come in late. All of that's going to go away. They're going to have to start punching in. I'm also concerned that there's very little ability to verify. If someone isn't out 24 hours, 3 consecutive shifts, it's going to be very hard to verify whether they're really sick or whether they're just late. And again, if you're due to come to work at 2 o'clock on a Friday afternoon and you don't show up until 4 and you say, oh, I was sick for 2 hours, that has an immediate impact on our service. That's peak hours for us. As far as the cost of this new sick time law goes, I would foresee that we're going to have to look at the other benefits we offer voluntarily and look at where we can fund this new regulation. We're very flexible in our driver scheduling. You can't work Tuesday, well, why don't you come in Thursday and I'll swap you with somebody else. We do that every day, all the time. That flexibility is going to be greatly diminished.
Did you say you offer vacation?
Yes, we offer full-time drivers. We offer 1 week paid vacation. We're pretty flexible about unpaid time.
So, one of the things just to keep in mind is if you offer access to time off and you don't restrict what it can be used for, if it can be used for sick time, you don't have to add anything to your.
Right.
You're in compliance with the essence of providing access.
My larger concern is my part-timers. Lots of part-timers, retirees, students, people between jobs. They work 1 or 2 shifts a week, and now we have this bookkeeping burden. My suggestions would be to raise the threshold to 25 to 30 hours a week, that you have to work 25 to 30 hours a week, somewhere in there, in order to qualify for paid sick time. So that someone who is a full-time grad student or a retiree and only works 1 day a week or 2 mornings a week
The statute dictates how you accrue and who gets to accrue, so we can't change that by regulation.
Can't be changed. Okay. And then the other thing is to increase that smallest increment to prevent abuse. So someone who has a problem with coming in on time now can't say, oh, I was sick for half an hour. Make it a 3. That's going to be almost impossible to track. And very difficult to manage in terms of disciplinary action.
That provision is also statutory, so we can't.
It's the
change
smallest
that.
increment.
That's in the exact language.
So someone
of the
can
law.
be 15 minutes late on a regular basis.
Well, yeah. I mean, I think you'll see in the regulations that if someone's not using the time for bona fide purposes, it's not protected time. So if you know they're not sick, if there's some way for you to know that.
How do you know? Someone has, I have migraine headaches. I'm sick. I was 15 minutes late because I was sick. It's impossible. At the very best, it's extremely difficult to manage that. Particularly given the nature of my business. I mean, these are not white-collar 9-to-5 workers. These are cab drivers. My option here, I mean, as I said, most of the universe, cab drivers are independent contractors. And this would not be, everything would go away, including workers' comp and the kind of protections that we think they really should have. It's an attractive option. It's something we'd prefer not to do because we think having employee drivers gives us a good, stable workforce. But this is going to be extremely difficult for us.
Thanks for taking the time to come in.
Happy to
Appreciate
be here.
it.
Thank you.
Joan Rustari? Rustari? It's okay. It's okay.
Thank you for being here today.
Thank you for coming.
And welcome to Framingham.
Thank you.
I'm rise to speak in favor of this. I think it's a long time past due coming, and personally, I don't think it goes quite far enough. Employers need to recognize the fact that employees are not indentured servants. Prior to retirement, I owned and operated a small business here in town for about 8 years with 2 partners. There were a total of 4 full-time people. That included the owners. We all worked full-time too. And 4 part-time people. We acquired the business because we all worked at the business, and the previous owner had sold the building we were in and planned to dissolve the business completely. So we put our collective heads together and put a business plan together, went to the bank and mortgaged our properties to the hilt and bought this to save all of our jobs. As I said, 4 of us worked 40 hours a week. 4 of us worked 20 hours a week. From day one, when we took over, all of us received regular pay, plus sick pay, plus holiday pay, plus vacation pay, based on time worked as follows. Full-time employees, it was after 1 year, but of course we'd already all been there over a year, so that was a moot point, except for new hires if we needed that. After 1 year of employment, those who worked full-time received 10 days of vacation, 40 hours of sick time, 4 days of paid holiday time. Those who worked part-time, and they worked 20 hours a week, got 5 days of vacation annually, 20 hours of sick time, 4 half days each time there was a paid holiday. And this, I think, resulted in having loyal, flexible, well-trained, trustworthy, very cooperative staff. They knew that we were in it together, And, you know, if somebody needed to switch with somebody, it was no problem. We all did what we needed to do to keep us all employed. And I think that that's the sort of thing that should be going on in all small businesses, but that's just one person's opinion. I am fully in favor of this. I endorse it wholeheartedly.
Thank you for sharing your thoughts.
Do you need this in writing?
If you have it
It's in hand scratch.
if you have it in if you want to either leave it at the back or send it via email to the address that is on Margie's behind you. She's going to take care of you.
Thank you.
Thank you very much. Okay. Danielle Terzar.
Thank you. My name is Danielle Tenzar. I work in human resources for Whole Foods Market. We are quite familiar with sick leave in various states, most recently Connecticut. One of the things that I would ask is, knowing that this goes into effect July 1st, that there would be additional guidance put out. This is a pretty quick turnaround for a pretty complex law with a lot of different provisions in it. In no way, shape, or form am I or the company against the sick leave, but I just think there's a lot here, and there's a lot more guidance and examples that needs to be put out for employers to fully comply. I know you spoke about earlier the hope that there would be additional training or questions for employers to really fully understand the law. However, with it going into effect July 1st, there is a great need for employers to be sure that they fully understand the law in order to implement it properly and correctly.
Can I ask, does Whole Foods have vacation time? And sick
Yes,
time
we do.
already?
We have a PTO plan.
Okay,
It's
so
combined.
If people aren't aware that we issued a safe harbor notice about 10 days ago.
Yep, no, I am fully aware of that.
Okay, just wanted to make sure,
Yes.
because that really, in terms of taking off pressure with companies that are already what we call doing the right thing and providing sick time, there's a lot of sort of room between now and January 1st.
July 1st.
January 1st. The safe harbor is for
correct.
purposes.
Yes.
Yeah.
Yes. However, the way our paid time off is accrued, it's accrued based off of service hours. And so for our newly hired folks, they're not going to be in compliance under our current plan. So there's still quite a bit of work to do on the employer's end. And for an employer,
To add them into the,
correct.
to the pool of covered
Correct,
employees.
yeah.
I
And we
got it.
probably employ about at least 6,500, 7,000 employees here in the Commonwealth. So one of the questions I did have was for an employer such as us that does have a paid time off plan, which we allow our employees to use their time off however they want. Say someone decides to go on their vacation to Hawaii in July, and they use their accrued time off. They use it up for vacation, and then they're sick, and so they have no sick time. Is that an absence? Is that not protected?
We can't answer specific
Okay.
PTO policy questions now, just because we can't look at your policy.
But I'm saying if they don't have any time accrued.
If they've exhausted their protected time, then there's no protection under the law.
Okay. So that's what I'm talking about in terms of clarification for employers. Again, when we implemented this in Connecticut, there was a lot more guidance with examples like that. So that's just one thing. Another thing that someone had mentioned earlier was the just kind of the overlap with FMLA and ADA. The requirement of the if you're looking for medical documentation and we're under this sick leave, that may not be required in that case. My other question was too, if someone is they're delayed, let's say 2 hours of their 8-hour shift because they had a medical appointment, and again they don't have enough time to cover that 2 hours. Is that still not protected? So maybe they had an hour's worth of time, but they were really gone for 2 hours. They don't have 2 hours worth of time. Is that protected or not? Part of it is, part of it isn't. So that would be another example that we would look for some guidance on. The other thing is just transferring locations. Folks who maybe work in California, in San Francisco, they have a paid sick leave law. They come to Massachusetts now. Is there any interplay, with other states with their paid sick leave, in terms of counting their time worked for the company in the prior state? So again, we look for some guidance on that. And then the last thing was just if someone uses more than 24 hours, the employer may request medical documentation, and the employee has up to 30 days notice to provide that. So you might have already paid the sick time out to someone because you can't delay in paying it, and then 30 days goes by, you can't get that verification. Is that then not protected, and are we then correcting that and taking that money back? So again, some guidance on that would be helpful as well. So my big concern is just the amount of guidance that's not out there for the July 1st date that this takes effect. The hope would be that there would be a lot more guidance. Like I said, we did this in Connecticut. There was a lot more guidance, a lot more training for the state, and it just made it a lot easier and eased the burden on businesses to implement and comply. Thank you.
Let me ask you one follow-up question. With respect to your question about employees who work in another state and move to Massachusetts and the interplay, can you flesh that out, what your specific question is?
I think just in terms of are we counting hours worked earlier in the year, the previous in the other state, and then in terms of they may not be accruing at the correct rate, depending on if they're accruing.
So,
just depending on when it's a little complex. I'm not sure this is the right form. I could submit it electronically with an example, but just there's some concern there about the transfer and then the accrual. Again, just making sure that we're compliant.
Yeah, no, that would be great for you to submit. Thanks so much.
Thank you so much.
Thanks for coming. Okay. Yeah. Going to double check. Michelle Weiner-Taylor.
Hi.
Good morning.
My name is Michelle Weiner-Taylor. I'm from Holliston, and I just would like to say that I'm in favor of this. Nearly 1 million hardworking people in Massachusetts, almost 1/3 of our workers can't take a single paid sick day and risk losing their job if they have to stay home to care for themselves, a sick child, or an aging parent. I feel very lucky. I have this ability to take care of myself, my son, or an aging parent. And I feel like without having this opportunity, I would have been worried about my job, but I don't feel that I have to worry about my job. I have been with my employer for 14 years. It has only strengthened my loyalty and commitment to my nonprofit organization, and I feel that it is a benefit that is very important to our workers. Last year, a majority of voters across the Commonwealth voted to provide sick time to 1 million voters, once again placing our state laws in step with our people's values. For this reason, I'm in favor of this legislation, and I think that you should consider what hardworking people need to do in order to balance work and family responsibilities. Thank you.
Thank you very much.
Thanks.
Is there anybody else who signed in but did not check that they want to testify? Okay. I don't think I have the last sheet. Okay. All right. Okay. There was a box on the form to check, and I think everyone has spoken who's checked the boxes. But why don't we have hands up again? Okay. We'll start from the front. Go right ahead. You could say your name. Thank you.
I'm Laura Wagner, and I'm the Executive Director of the Unitarian Universalist Mass Action Network. As a member of a faith community, I believe we must value the hardworking people of the state. We must honor the vote that took place in November and will require workers with a chance to earn paid sick time. It has been 6 months. My concern about bookkeeping and these delays that somehow are going to be resolved in 6 more months are a concern to me, because in the meantime, people are having still to face, if they're sick, they have to lose a day's pay. So that is a delay that concerns me. As we mentioned, there's 1 million people in Massachusetts. That's almost 1/3 of workers who can't take a single sick day. And we talked about this when the vote was was happening last year, it benefits all of us. It's not right to have to send sick kids to school because their parent can't take a time off, to have a sick employee serving you food or working in a hospital or just any kind of environment where we interact with each other, to have to choose between, I mean, there's many people that they can't get by with a day off of no pay. So I think to remember the significance of how this protects people is very important. I think the Attorney General has developed a fair and balanced regulation implementing the ballot question that was passed overwhelmingly by the voters last year, and that also supports responsible businesses that already provide sick time to their workers. I think somebody said earlier, workers aren't indentured servants. I think that's very important to remember that they're people. So to have no provision for sick time or something drastic happening in their family is not reasonable and doesn't value them as human beings. In the faith community, we really like to emphasize that these are human beings we're talking about. This law gives workers the right to start earning sick time beginning on July 1st, and nothing should stand in the way of that. Denying them the ability to do so violates the will of the voters in Massachusetts. A lot of people came together on this, and our voice was heard loud and clear. And to stop it now for the argument about bookkeeping just doesn't sit well personally with me. I'd just like to add we're grateful that the Attorney General for moving forward with the July 1st effective date for this earned sick time. Thank you.
Thank you for sharing your thoughts. Okay. The gentleman in the beige.
I'd like to start with the Attorney General's Small Business Impact Statement issued on April 24th. I find it entirely lacking in specificity. It does not quantify the cost of this legislation. It doesn't address the litigious can of worms that this law will open.
Can I ask you to identify yourself?
Sure, Ed Holston.
Ed Holston. Okay, thank you. Just for the record, thank you.
So while you've been saying that the statute prevents the Attorney General from amending certain provisions of this law, I would recommend that the Attorney General go back and revisit the small impact statement to add that kind of specificity to address the litigation can of worms that this is going to open and the cost that it's going to cause. I mean, I look at point 5, and the question is, analyze whether the proposed regulation is likely to deter or encourage the formation of new businesses in the Commonwealth. Answer, the regulation is unlikely to deter or encourage the formation of new businesses in the Commonwealth. I don't think you have to be Professor Kingsford to say, that isn't ready for a prime time answer to that question. In terms of addressing the administrative costs, there's no quantification. It just tells you what people will have to do. Maybe if people somebody sat down and said, what is it going to cost per employee to do this, and put it in reference to that, maybe people's attitudes would change. Maybe the legislature would act. So I'm saying I think the Attorney General is papering over, with this impact statement, the real costs of this, and I think they should be revisited and provided to the public and to the legislature. My question here is, who is going to pay for the MBTA if everybody's working under the MBTA's work rules? We see what a disaster that has been. Here it comes. It's going to hit the private sector, the people who have to pay for that nonsense. As the woman before said, if you can take increments of 15 minutes, 40 hours is 160 late arrivals to work. 80 if you take a half hour. Good luck with that one. Getting back to the litigation point, I'm looking here, and it was in the question, and it is in the statute, I believe, but under Section 33.08, it shall be unlawful for an employer to take any adverse action against an employee because the employee opposes practices which the employee believes to be in violation of this section. Now we've entered the realm of thought crime. This is where the litigation explosion is going to come from, and I've never heard anything like that in my life in a statute about the subjective opinion of a person who's going to be bringing the suit. I'm sorry, I think it's crazy. The safe harbor provision, that to me looks like a completely backroom political deal. What do I say? The big guys who have plans in place, it's a huge burden to add 10 hours to that, but imposing 40 hours of new required time isn't, well, it doesn't make any sense to me. It just doesn't. It sounds like political posturing. AIM is powerful on Beacon Hill. The next round of elections come up in what? 18? They don't want AIM on the opposite side, so let's give them throw them a bone that the small employers don't get. It isn't even really clear to me in the regulations how you ascertain that somebody is claiming sick leave rather than just not showing up for work. Do you ask them to submit a form? Is that allowed? Can you ask them?
You can. In the regulations, it makes clear you can require them to submit a form, and there are requirements about providing notice before, not providing notice and then verifying what the
Attorney General's model form?
The regulations.
So you're referring to the Attorney General's model form? Is that what it's called in Section 3306, Paragraph 2?
It's in the regulations 3305, notice of use, and then there's documentation. The model form is a model form, but there's the regulations state what you can ask for.
Now, am I correct to understand that the whole, getting back to the litigation thing, that the whole kit and caboodle of triple damages, attorney's fees are going to be all invoked over a 15-minute, litigating a 15-minute late arrival?
Can you explain when you say the litigation thing, can you explain what type of?
Well, my understanding is that the law references to the wage and hour provision, which does give people a cause of action, which does give triple damages, which does give.
But what kind of violation are you talking about? Explain the circumstances that you think would lead to litigation.
A situation where an employee shows up late or doesn't come in.
And why would that, if they are not using earned sick time?
If they invoke sick time, yeah. And you say, no, this is baloney. If an employer tries to continue to use what has been the time and attendance policy in effect for maybe decades, now it may be unlawful. Mm-hmm. And I'm saying, does this invoke the provisions of the wage and hour law, which gives a right of action, which gives triple damages, which gives attorney's fees?
Mm-hmm. The only time that is protected is bona fide use of earned sick time. If someone's taking care of their family member or they're themselves sick, for those delineated purposes, that's it. If you're talking about you have employees who are cheaters and liars, that's it.
But that issue has to be litigated, doesn't it? I mean,
what issue? I'm not understanding
whether that was a bona fide use of the paid sick leave or not.
Why would it have to be litigated?
The employee says I was sick. The employer says, you're not showing me any proof. I don't believe you. I'm going to impose my time and attendance policy with progressive discipline. The
law actually does not. I mean, you can ask for post-use verification and to be signed. I mean, a form to be signed, but you can't ask for documentation except for in pursuant with the statute. And so, if you're saying you're planning to impose documentation requirements that are more restrictive of the use of earned sick time, then you might have a problem because you'd be violating the statute.
Right, but if there's a disagreement as to its veracity on the form, that is allowed. And you say, no, I'm not going to pay you, and in fact, I'm going to suspend you for a week because you showed up late and you didn't have a real reason.
Well,
They're going down
there's no, you can't take it for no reason. It's not vacation time, it's not personal time, it's for specific use.
Right. So the employee says no. It's not a use. The employee says yes. That's the employee believing something. They're going to go to Union Street, they're going to find a lawyer, they're going to come in and sue. The lawyer's going to say, hey, let's take it to the bank because I can get attorney's fees first.
What would they be suing for? I'm trying to understand
That's what I'm trying to find out is this under the wage in our provision, which gives the cause of action? That's what I'm...
The cause of action, a cause of action would be denying the use of earned sick time, failing to pay earned sick time if there's an obligation to pay it. There are delineated violations.
Right, but if there's a disagreement between employer and employee, it goes to litigation. That's the resolution, isn't it? Do you have to exhaust administrative remedies first? There's nothing in here specifying whether this goes right to wage and hour. Or, what does the employer face here?
If there was a violation that the employee wanted to file a complaint about, they could file a complaint with the Attorney General's office.
And that's it? There's no...
They could also file a complaint and ask for a private right of action. I'm not sure what the concern about 15 minutes would be. I'm trying to understand where you see there being an issue. But I think we need to move on. I take it you're not. You feel like it's...
No, I think you're dodging it. There's a disagreement between employer and employee. Where does it go? Does it go to the Attorney General? Do administrative remedies have to be exhausted? Do they have a direct right of action to the mass wage in our law? That's what I don't see here.
I just explained that it's referenced in here. The law, you can file a complaint with the Attorney General's office, and you can also file a complaint and request a private right of action. There's two ways to go.
But do you have to go to the Attorney General for permission to file that private lawsuit?
I do believe so. I think it's in that. I think that's referenced, Chapter 150, and after 90 days, Chapter 149, Section 150, I believe is referenced in the law, and after 90 days, you have an automatic right. Yep.
So you're off to the litigation races. And so an attorney is going to sit there and say, hey, I can probably rack up about 100 hours of fees, put it on an employer because there's a disagreement about a half hour or 15-minute late arrival. Again, I would urge the Attorney General to actually do the job and fill out and answer the questions about the small business impact that this legislation has.
Okay, thanks for sharing your thoughts. Hands up still. Okay, on the right.
My name is Kathy Tobin, and I'm from Roach Brothers Supermarkets.
Can you speak up a little?
Okay, sorry. Kathy Tobin from Roach Brothers Supermarkets.
Okay, thank you.
I'm actually just looking for some clarification on the accrual versus the rollover balances. And there's some confusion and misunderstanding, I guess, on my part. It says here that the law states that you can accrue 1 hour for every 30 up to 40 in a year. And it also states that you can roll over up to 40. And if you roll over up to 40 into the next year, have you met the accrual requirements for that new year? Yes. So that if somebody in 2015 earned 40 hours of sick time, rolled it into 2016, never used any, rolled it into 17, they would technically only ever have accrued 40 hours in 3 years.
The law provides access. It's not, you're not banking anything. You are getting access to use time. Okay. So if you don't use the 40, it rolls over. If you don't use it again, it rolls over. The employer's not paying anything out.
So if they use 40, they roll it into 2016, they use 40 hours in January, the employer is not obligated to accrue any more for that year?
if the employee has had access to the 40, it's a minimum access requirement, access to time.
Okay.
If the 40 hours has been provided and used, then there's no further requirements under the law for the employer.
Okay.
The employer might have its own more generous benefit policy, but with respect to this, it's providing access to time off that is otherwise not required.
All right. Excellent. Thank you.
Okay, you're very welcome. Okay. Go ahead. Can I steal another piece of paper?
Good morning.
Good morning.
I'm Jenny Lee Colosi. I'm owner and president of ET&L Corp. We're a 70-year-old heavy construction company. We build the Commonwealth's roads and bridges, airports, landfills, and dams in the state. And we have
Can I stop you? Can you restate your name?
Sure. Jenny Lee Colosi.
Colosi.
Yes. So we're under a little different circumstance. We have about 50 non-union employees who get paid time off, 3 medical absence days, and they can get 2 weeks, 3 weeks, 4 weeks. And a lot of those people are expecting another 5 days of the earned sick time.
Why is that?
Because that's the law.
But they already have paid time off?
Yes.
Okay. You don't have to provide additional paid time off if you don't restrict what the time off that you provide can be used for. If it can be used for sick time, you don't have any obligations to provide additional time.
Do you want to come and tell my employees that? Because I'm afraid I'm going to have a mutiny.
It's in the regulations. It's just, again, it's access to time off in case you need to use time for the particular reasons set forth in the statute, and that's all it is. So if an employer has a PTO that provides up to 40 hours of time off per year, and it accrues at least at the rate of 1 hour for every 30, then with respect to what you need to provide, you're set. And it's in the regs, so I don't think I need to personally visit there. but it'll also, we're putting together a lot of fact sheets, and they'll be updated on a regular basis. And we're trying to make those as accessible as possible. So you can point to those.
The other part of our company, being a seasonal business, being in New England, are union employees, and we have about 100 union employees. And those people are going to get 5 earned sick days. Okay, so if they get 5 earned sick days, our non-union
do they not, and they don't have
they
other
don't
time?
have anything in their collective bargaining agreement right now for that. And if they get those 5 days, they're going to get their base pay, say it's $40 an hour, and then they're going to get their fringe benefits, which may be $30 an hour. So they're going to get $70 an hour for being sick. So that translates to $2,800 a week times 100 employees. That's $280,000, and that's not including non-union tracking, paperwork.
If in the regulations, if you go to where same hourly rate is defined, and you go down the list to what the exclusions are, you will, under one of the federal regulations cited, contributions to benefit plans are not part of the regular hourly rate. So it's under the Fair Labor Standards exemptions, section 207E.
So is the AG's office going to provide us posters and some kind of notification to put in employees' paychecks?
I'm sorry, I'm not sure.
For this new law. It's just like we have project posters for minimum wage.
Yeah, we're actually in the midst of revising a lot of our materials, and one of the things we're planning to do is to add to the mandatory poster, the minimum fair wages poster, the wage and hour poster, a provision with respect to the earned sick time law, and there will be lots of information on our website, fact sheets, etc.
Another concern is some of the union employees. Sometimes they work for more than one employer during a year. So potentially some of those individuals could accumulate more than the 40 hours a year, which isn't really fair to the employers. And we really could use more time to figure this all out. If we get something on June 19th and then we have to scramble, in 10 days to figure out what our policy is going to be for our non-union and our union people, it's going to create quite a burden on us. So we would appreciate more time.
Thank you very much.
Thank you.
Okay. I'm going back. Yes, thank you.
Good morning.
Good morning.
My name is Julie Brennan. I'm an employment lawyer in Massachusetts, and since November I have been working with my clients to try to modify and develop policies to comply with this new law. The good news is that many of my clients had generous paid time off programs to begin with, but we're struggling with determining what modifications need to be made to achieve compliance with the new statute and the regulations. So many of the questions that we had were answered by the regs, so thank you for that. I'm sure not many people are thanking you. But there are a few questions that remain outstanding and a few obstacles that a lot of my clients are tackling this and having the same problems with respect to making the modifications. So I really have only two topics that I wanted to address today, but I'll certainly submit comments as well in writing. The first general broad topic that my clients are having difficulty with, you've heard about already a few times today, which is the incremental use of this paid time off. Because obviously, if an employee does use 40 hours of paid time off a year in 1 minute increments, that can really be disastrous when you multiply it by a number of employees across an entire business. And so I have read probably 1,000 times the language of the statute where it talks about what the appropriate increment needs to be in the policy. I would maintain that it's less than clear in the fact that it does reference that it needs to be a 1 hour increment, but there's also some additional language about the employer's payroll system and what the employer uses to track time off. And I think that the ambiguity arises because some employers have payroll systems that are very sophisticated and track time to the minute. So if someone comes in at 9:08 and they leave at 5:04, they literally get paid from 9:08 until 5:04. But that's not necessarily tracking their time off. That's determining their hours worked to comply with the wage and hour laws. But many clients of mine had existing policies, like a PTO policy that said, we will give you 80 hours a year of paid time off, but you have to use it in minimum increments. Sometimes it's 1 hour, sometimes it's 4 hours, because that's half a shift, sometimes it's 8 hours. So it would be helpful if the Attorney General reviewed the language of the statute, looked at that specific language, and actually clarified the regulations to say, this time off is not available in 1 minute increments. It's available in the lesser of 1 hour, or what your existing PTO and other time off policies use for a minimum increment of time. Because the 1 hour minimum is really the obstacle for most of my clients. And the good news is that I think a lot of Massachusetts employers, even small ones, have been generous and have given these paid time off programs. But it's this incremental use that's particularly problematic in implementing. Some of my clients don't have a system to track it, and so they're struggling with that because it's just an administrative burden to track the time off. But others do have these technical systems that can track to the minute, but now that's a detriment to them because now they're apparently may need to track to the minute when it comes to taking sick leave. So if I would encourage the Attorney General's office to revisit that regulation to see if there could be some clarification around the incremental use. The only other topic that I did want to raise that I would encourage the Attorney General to review the regulations is in Section 33.07, which is a section that I think many employers in Massachusetts are reviewing carefully because we're trying to take existing sick and PTO policies and modify them to be in compliance with the regulations. Unfortunately, there is a typo in one of the regulations where there's sort of a dangling or at the end of a list. So we're left with, in Section 33.07, paragraph 2, it gives some an introduction, and then it lists A through E, and then the very last word in E is or. So when you read through this, we can't quite figure out whether we need to, our sick leave policy needs to achieve one of these points in order to be in compliance, or whether there was an additional subparagraph F that was initially there and perhaps deleted and never revised. So it would
we will fix that.
It would be helpful because I think that changes the definition, and if it is an or at the end of D, it might be helpful for us to understand that as long as we have a sick policy that achieves one of subparagraphs A through E, we're in compliance. But the other open issue...
Yeah, I mean, these were intended to be examples of more generous policies.
Okay. And so if a client has a more generous policy and can tick one of these boxes, is it in compliance automatically, even if they, for example, ask for documentation after 8 hours instead of 24?
No.
So, in other words, the requirement is that it has to meet all of the other requirements in the regulations and be able to check one of these boxes. When I read these regulations, it doesn't say that. So I would encourage the Attorney General to go back and review that section of the regulations because I don't think that's clear.
Okay.
And the same goes for the PTO substitution.
I just wanted to point out, it just says the introduction is employers may deviate from the accrual rate if they provide more generous sick leave or other paid leave policies. So it's really just
ticks the box for the accrual rate
exactly.
if we can meet one of these examples.
Right.
Okay.
Right.
And then with respect to the PTO section, where we can look to whether our PTO policy currently complies with these regulations, it also would be helpful to understand whether it's similar to the sick leave substitution in the sense that this just allows us to tick the box for the accrual rate, or does this allow us to check the entire box for compliance such that if we meet A through E, our PTO policy is in compliance and we don't need to read the other sections of the regulation. Because there are provisions in the other sections of the regulation that are in addition to the ones that are listed right here. And so it would be helpful if we understood that if you have an existing PTO policy and you're trying to use it to comply with the sick leave, you just have to read A through E and make sure you can check all those boxes. And that, to me, isn't entirely clear at this point, and a lot of my clients have struggled with that as well.
Yeah, I mean, again, I think this is just with respect to the accrual piece. And that is not, it wouldn't do away with other documentation or notice or other requirements.
I certainly can see that as the introduction to the sick leave substitution, but that's not the introduction to the PTO substitution provision. The PTO provision says in order for paid time off, vacation, or other policies to be substituted for the time off from work provided under the statute. So when I read this regulation, we're looking to this regulation to achieve full compliance with all of the regulations, and so we just need to meet A through E, and it has a different introductory clause than the sick leave.
Yeah, okay. I think it's intended to be just substitution for the paid time off piece. Like, it's a very narrow construction, but it sounds like that needs clarification. Thank you.
Okay. And then the final point, I know you mentioned that we can ask for verification from employees. I did hear rumor that the AG's office was going to publish some sort of a form that could be used by employers that we could ask employees to check the box as far as which type of leave they took and perhaps sign it or something. Is that the case, and when would we expect a form like that to be published?
Yes, is it not up on our website already? Our verification form? It will be on the website.
Okay. Thank you.
Yeah, before July 1st.
Thank you for your time.
Okay, thank you, Julie. Okay. Back right. Okay.
Hello.
Hello, how are you?
Good, thanks. How are you? So my name is Anthony Karpouzis. My wife and I own a business out in Westboro. So just like...
Yeah, can you pull up to
sorry.
the microphone it's being recorded for public records.
Sorry. My wife and I own a business out in Westboro. It's just like the YMCA or just like the campground place. We employ high school and college kids as well. So it's just a gymnastics facility. And on average, it's anywhere between 10 and 15 employees. So something like this, when I first came here, I wasn't going to say anything. I was just more nervous about how it was just going to affect my business. But the more and more I hear all of the other points and all the other issues, For me, I just would ask that you guys would postpone it at least until January, until all of these things get tweaked, because
the date is actually in the statute too, so we can't postpone it. The legislature could postpone it. We cannot do so.
Well, I mean, then hopefully tell someone to do it. I mean, for me, it's more of a, I really don't know any other way to describe it. It's one of those things where, I. Looking at it from my perspective, our employees, again, high school and college kids, the beach day example was a perfect example of what we deal with as well. I had someone who works, 30 hours a week try to take a day off just because he was hungover because he turned 21. So what I have to do is pay him a day off for being hungover, and then pay somebody to cover his shift. And as a small business owner, it's going to kill me. I mean, we've been open now for 7, 8, 9 years now. We're in our 9th year, and it's just things like this, and when we teeter on the 10 to 15 employees based on our busy time, it almost makes me have to consider, well, then maybe I have to get below the 11, and that's the last thing I want to do, because we have so many kids that are, we have so many high school and college kids that everyone has to cover for each other. Right. So that's why I have to employ as many kids or people that I do. So something. And being a franchisee too, one of the worst things as being a small business owner and a franchisee, there's nothing worse than having the headquarters roll out stuff that they've never tested, roll out stuff that they have no idea how it's going to work, and then they expect us to give it a shot, and if it hurts us, oops, we'll fix it later. And that's what this seems to me. It seems like it's not completely ready yet. I'm not against the plan. I completely understand it. I know why it's in place. It makes sense. It's just, it seems like there's way too many things that just aren't, like all the T's aren't crossed and the I's aren't dotted. It just seems a little too scary for me, and it's going to end up hurting my business a lot. I know it's just my own personal stuff, but I wanted you guys to understand that something like this is going to make me look at how I run my business and how many people I'm going to employ. Because not only do I teach classes, but I clean the toilets and I do the payroll. So as a small business owner, you're pretty much doing everything, and I have to rely on ADP, to do a lot of my stuff. And ADP isn't ready for this. Nobody, the people that I deal with that help me as a small business owner have no idea how to answer my questions. So until all the questions are answered, and ADP and all of those other, Paychecks and all those other companies that we rely on as an HR, as they help us out with their HR stuff, they help us out with the payroll, until they're ready, and until all of the checks and balances are in place, and spreadsheets and templates. Someone mentioned templates. That makes perfect sense. Anything like that, until that stuff is all ready, just kind of hold it off just a little bit. Or
do you have any kind of paid time off at this point?
We do for the full timers. I mean, it's that thing.
So it's just the part timers.
Yeah, it's our full time. We have 2 full timers, and then we have a bunch of part timers because they're all high school and college kids, and their availability changes based on class schedules or sports or a nice beach day. So it's one of those things where we have to take that into consideration. It's just especially for a small. I mean, and when I say small business, I mean we're tiny. And this is going to kill us.
Thanks very much for coming.
Thanks.
Okay, to the on the right, yes, thanks. Good afternoon.
My name is Bill Zoll. I'm of counsel at the firm of Cunningham Mechanic, Settlin here in Natick. They're in Natick.
You said Zoll.
Zoll,
Okay.
Z-A-L-L, yes. Okay. I did submit a written comment. However, some inconsistencies have come up today that I'd just like to address very quickly, and there are 2. That I'd like you to look at. Number one is the representative from Whole Foods talked about PTO, and the response was that if it has a greater accrual or greater amount, they've met the statute. Unfortunately, the way that's
they've met the accrual piece of the statute. There's a lot of other parts to the statute.
Okay. My concern is that I don't read in the regulations of the statute where you could have a PTO policy that allowed the employee to use all of their vacation time early in the year, let's say, and not have a sick time accrual or a sick time put aside. And that's bolstered by a provision that you've put into the regulation that says you cannot pay out your accrual, your sick time accrual on a monthly basis. That's tantamount to using it as a vacation time. So my concern is, as written, the statute can be interpreted as I have to have 40 hours or whatever the equivalent is, depending on how many hours I work each year, available to me for sick time. And that, as written, I'm concerned that if an employee uses more than the 40 or 50 hours of PTO and gets sick at the end of the year, there is a mandatory requirement that it must be available for purposes stated in the statute. So if you could address that again in your revisions. But I am concerned, again, you do have the one provision in there that talks about you cannot pay it out monthly. I'm not sure how that differs from taking it as vacation time. Okay.
I'm not sure. I don't quite follow that last comment.
Well, there is a provision here that says, I apologize. Of course, I won't come up with it right away.
I know exactly what you're talking about. I'm not understanding the connection with vacation.
Let's assume that an employer gives 120 hours of PTO. Doesn't require notification, doesn't require sickness, and the employee takes all 120 hours before the beginning of the year. I think
then if they're done, they don't have any more time.
The inconsistency in the regulation then is twofold. Number one, there is a mandatory that says that time must be available for the purposes. And
if you're giving PTO time at least 40 hours and you're not restricting its use for sick time purposes, if it can be used for whatever purposes the employee wants, and including sick time, you're done meeting that requirement.
I understand, but the inconsistency and the clarity I'd be looking for in the regulation is that if it cannot be used on a monthly basis, you cannot pay it out each month. I believe that paying out it could be seen as tantamount to using it for another purpose, and that goes over.
What do you mean by that? I'm not understanding that.
That I can use my sick time accrual for something other than sick time, whether I take it as a payment or whether I take it as another benefit in kind.
Okay, so
which is a
you mean
concern.
like you take a vacation, you get paid for the vacation.
Right.
That's different. That's not that. We're going to be clarifying the payout piece. It was it arose in the context of some employers not wanting to keep any time on the books, and they thought maybe they could just pay it, and then that doesn't provide any access to time. So that was why that came in. So
okay.
I understand that. Thank you.
And my second issue, the issue on carryover, I'm concerned that the statute uses the words earned time throughout, as do the regulations, and you're characterizing it as time available. And if you read the regulations as a whole, it says that you can carry over 40 hours, or you can pay out what seems to be 24 of those hours, so that 16 are available at the beginning of the next year. And I'm concerned that there's an inconsistency in the characterization. As written, I think that the statute could very well be interpreted as you earn 40 hours a year, you can carry over the prior year's 40, so that this year you get 80.
Okay, that is not the case.
Okay, that's the way that the regulation's taken as a whole, especially using the word earned and suggesting that I can only pay out 24 because 16 have to be available. If in fact
you're
16
earning the access to the time, to taking the time, so you're earning it by virtue of rendering your service to the employer.
Okay, again, I was just asking the review of the regulations that be made clear that earning doesn't mean that the employee gets to bank the time, and that's all.
Okay.
Thank you.
Thanks very much. Okay.
How you doing?
Good. Good afternoon.
I'm Rudy Jean. I work for the
Rudy
MBT.
Jean?
Rudy Jean.
Can you say it again?
Rudy Jean.
Rudy Jean. Okay.
I work for the MBTA, and I wanted to know how do we fall into it, contrary to what the newspapers say as far as us with sick time. We don't really get paid for sick time. So how do we fall into it as an MBTA employee? As getting paid for it, do we fall into?
You're covered like all other employees in Massachusetts, except for cities and towns and federal. The towns and cities who haven't yet either voted to adopt the law or appropriate for purposes of covering the law. And federal government employees are the only exempted employees, so you're covered.
Okay, thank you.
Okay, thank you. Okay. In the back row, thanks.
Good afternoon.
Good afternoon.
Miranda Jones from the law firm of O'Reilly, Grasso, and Gross. I'm a labor and employment attorney, and I wanted to just do some follow-up clarification based on one of the prior speakers pertaining to benefits. My understanding about the regular hourly rate is that it's wages and benefits unless those benefits are excluded under federal law, under Section 207, as you alluded to. My concern, however, is that there are certain employers out there who are signatory to certain collective bargaining agreements. And those collective bargaining agreements specifically say that wages and benefits are paid for not hours worked, but actual payroll hours, which arguably a sick time hour would constitute a payroll hour, not an actual worked hour. And as you know, the law specifically states that the law does not infringe upon any rights that are guaranteed in collective bargaining agreements. So in the situation in which an employer is signatory to a collective bargaining agreement in which benefits are paid on all payroll hours, my question to you is, are they then required to pay the benefits for the sick time pay? I would suggest that they are, otherwise that they would be in violation of their collective bargaining agreement, which would cause grievance arbitration. So for purposes of clarification, for the public, particularly the signatory contractors who are out there, could the Attorney General's office go into a little bit more detail on the hourly rate? Because right now I see a contradiction as the regulations stand versus what their obligations are under their respective collective bargaining agreements.
Okay, but the law doesn't. I mean, when you say that, why is there a lack of clarification? We're not talking about anyone's particular.
No.
If an employer has a more generous policy, contract obligation, etc., this is just setting a minimum. So.
I understand that, but your response to the prior speaker was that benefits aren't included if they fall under Section 207. Agreed. However, you have to look.
For purposes of the law, that's
you have
correct.
to, right, for the purposes of the law, correct.
Right.
But you have to look to the terms of the collective bargaining agreement. Certain collective bargaining agreements say benefits are paid only for actual hours worked. But there are others, two off the top of my head, Operating Engineers Local 4, Iron Workers Local 7. Both say that the benefits are paid on payroll hours. So it needs to be clear, because I don't think, for example...
What needs to be clear?
That you have to look to the terms of the collective bargaining agreement to see if benefits are required to be paid. I see a contradiction in the language of certain collective bargaining agreements in which you would have to pay benefits, and so I don't think
I think that's a separate obligation. It's like a private contractual obligation, not part of the statute.
I completely agree. But to give this an answer to say that you only pay benefits unless you don't have to pay benefits. Wages and benefits are included unless they're excluded under the federal law under Section 207E.
For purposes of law, this law, that is correct. And if you have your own contract obligations, that's a totally separate issue, and we have nothing to do with that.
I agreed, but I think there's a caveat there in that you just can't say across the board you don't have to pay benefits if they're excluded under Section 207 because your collective bargaining agreement, whichever the agreement is that you're dealing with, maybe in fact require you to still pay.
I'm just clarifying what the law's requirements are,
I agree.
and others. We don't provide legal advice on like private contract issues. So
Understood.
I'm assuming people know what their obligations are.
Right, understood. But the question was posed, the answer was given. You don't have to pay benefits if they fall under the exclusions from Section 207.
For purposes of the law, that's
for purposes of the law.
And that's all we're talking about.
Okay.
Yeah.
Thank you.
I
just think that this isn't a one-size-all law. It can't be. There's just too many different industries, too many people have obligations under private agreements, such as collective bargaining agreements, that it's very difficult to fine-tune every single fact scenario that possibly is going to be out there in the employer-employee relationship. And in terms of seeking guidance, and certainly there'll be a lot of employers who come to legal counsel asking, but there's also a lot of misinformation being spread because it's not quite clear yet. But thank you for your time.
Okay, thanks.
Good afternoon. My name is Elizabeth Toulon, and I'm a senior attorney at Greater Boston Legal Services.
Good afternoon.
And I just want to thank the Attorney General and the staff for a very thoughtful public process, accepting input from the public. And I just also want to state that, we've received questions as well, some very similar to what I've heard here today. I think the dilemma, and we've heard it from a couple of witnesses here, but also more at other hearings, is the dilemma faced by the 1 million workers that today don't have any job-protected sick time. There are so many employers in Massachusetts, 2/3 right now, that do provide such benefits, and they are to be applauded. And I think the Attorney General's safe harbor recognizes that the dignity of those employees are respected by their employers, and as a result, since they're substantially in compliance, they will be given this additional time to make the payroll adjustments. We are the only developed nation, and we are in the company, actually, of some very oppressive regimes in not affording workers in Massachusetts and throughout the country with this guaranteed protection, except in a couple of cases where the law is passed elsewhere. There are developing nations that provide this benefit because they recognize the dignity of the worker. There are changes in the workplace that have taken place over the last 40 years. In many families, especially low-wage working families, 2 parents are required to support the family. They have to work, both parents have to work. And when a child is sick or a worker is sick or a family member is sick, those families cannot afford the loss of a day's wages, worse, a job, if they need to meet their health needs or those of a family member. I thought the points made today by some of the employers and their representatives are well taken about concerns about employee abuse. When it comes to employees in the private sector, where similar laws are in place in other jurisdictions, the average uptake is 2.5 to 3 days a year, primarily because employees treat the time off as insurance. If they use it when they don't need it, it won't be there when they need it. And research done in Massachusetts actually shows that lower uptake rate of 2.5 days. And I'll just add that that is in the private sector, and most of the employees in Massachusetts who lack access to job-protected sick time are in the private sector. Most public sector employees have this benefit already. There were some other points raised, and I think this give and take is precisely what the Attorney General contemplated, getting this input and being thoughtful, giving everyone an opportunity to provide written comments and suggestions for changes. That is appropriate. The stories that we heard over the years in an attempt to move this issue in Massachusetts is what kept the campaign going for 10 years with the legislature. And because of the failure of the legislature to act, directly affected people took this issue to the voters. And along the way, testimony was offered in multiple venues about just tragic situations. And I know you were at the hearing in Boston earlier this week when a woman who had worked for Jet Ready, reported having a miscarriage, supplying
Ready Jet,
rather.
Right.
Yeah, Ready Jet, right.
Just for the record.
For the record, right. Reported, suffering a miscarriage, having to be out for 2 days for medical reasons, supplying a note, being fired, losing her housing, and ending up in shelter with her firstborn child. These are the kinds of situations that are deplorable and fail to recognize the dignity of workers, fail to take account of the fact that people actually have obligations to their own health and those of their family members. Around the teens, I hear what people say about hangovers and the temptation of going to the beach in the summertime. Again, in low wage, and because our organization represents primarily low wage, all either low wage or desperately poor people, what we find in our client family situations often is that young family members, teenagers, contribute to the support of their families. The money that they earn gets turned over to the parents to help meet the needs of the family. And these are not young people who are saving up to pay for the limo for the prom or the prom dress or to get their nails done. This is putting food on the table and paying the rent. There's unfortunately a population of adults, teenagers who don't have parents, who may be in guardianship situations or in the custody of the state. Again, I just stress that these are kids who are trying to make their lives better through work, saving up for college. Their employment is not discretionary or luxury. It is a necessity.
Okay. So, thank you very much.
Thanks.
Is there anybody else? Thank you.
Thank you for the opportunity. Can you hear me okay?
Yes, thank you.
Thank you for the opportunity to speak today. It's interesting listening to all these previous comments, because the one thing that does resonate with me is it really is difficult to have a one-size-fits-all law, and I hope that the Attorney General takes that into context. I'm going to tell you who I am.
Okay, good.
My name...
Thank you.
I just wanted to get it while it's fresh, because I think in balance there's a lot of good things here, but I think the difficulty is always in the implementation. My name is Chris Markowitz. I am a board member of the All Newton Music School. We are a nonprofit, music school only. We've been in operation for over 100 years, and we serve not just Newton, but all of Boston, really. And we provide scholarships and so forth to people of need. This is, however, a very difficult thing for us to implement. And as such, we're seeking some sort of special designation. Let me explain to you how our business works. We operate totally with tuition. So you subscribe to a certain number of lessons, a teacher shows up, you have the lesson, we pay the teacher. We have about 50 or 60 faculty. They're all part-time. They all have advanced degrees, so their compensation is significant. It's not, they don't make $10 an hour. They make many multiples of that, as anyone who takes music lessons probably knows. But in the event, the way we interpret this law, in the event a teacher and it's common practice in our industry for when lessons are missed for whatever reason, and they're not usually not missed much for sickness, but like teachers will have gigs and they performances and they can't be there. Students are going skiing for the weekend that weekend, so they skip a lesson. So it's very common for us to juggle, cancel, rebook lessons. In this scenario, what we potentially would have is if a teacher was sick, and normally that's just made up, the teacher is guaranteed to be paid for all those lessons, provided they are delivered. So in the event that the teacher could not make up the lesson, and I don't know how that would happen, but in the event they could not or chose not to, we would have to pay them for the lesson and potentially refund the tuition, so it kind of hits us twice. We calculate the net impact of this on us, and we're a small operation. It would be about 3% of our revenue. Now, we run year to year pretty close to no net surplus, no net deficit. I mean, a couple $1,000s each way. This would be a 5-figure hit for us, and we would not have the ability to recover from it if it was used. We would have to raise tuition, which even though we're a nonprofit, we do face competition from home teaching and so forth. And again, our mission is to provide education to a community. So our competition is in the sense of only trying to preserve what is a resource to the city and to the community at large.
Are you part of the National Guild of Arts Education?
I think so. We belong to a lot of things. And I'm surprised, actually, there aren't other folks like us here. I'm sure in some of the other hearings in the state that will happen.
We have heard. So it's essentially a fee-for-service arrangement.
It's a fee-for-service.
And you have, as a practice and policy, part of the way it operates is just you make up the time. You make up the time,
and it's common practice. Right. So this would really add something new to us. And
but this contemplates makeup. By mutual agreement, an employee can make up time. Make up time so as to not use earned sick time.
Right, but if they decided for whatever reason that, so a typical semester 16 lessons, if they decide they missed 2, all right, and they decided not to make those lessons up, under this law we would still have to pay them for 16, not 14, which is, it would add about 3% to our and we just have no real ability. And I think most other community music schools have really limited ability to recover that. I mean, the arts in general, struggle even in good times here. So it's a heavy burden. So I guess in summary, I would just say, I don't know exactly how you architect it, but I think there should be consideration of some special designation for entities like this. They're nonprofits, they're schools, they're serving the community. There is a way, certainly the teacher does have access to earn the money. So if they want to get paid for 16 lessons, they absolutely will get paid for 16 lessons as long as they show up, and they can do it whenever they want. And again, in common practice, that's generally how it works.
Right. I mean, part of the important aspect of the law is job protection.
Mm-hmm.
So it sounds like in your situation, there's no concern about someone losing their job because they're sick. They
Absolutely
just
not. We spend a lot of time recruiting, and we're fortunate living in Boston that we have access to really a wonderful. There's a lot of great musicians here, but employee would never. I can say this pretty safely. Would never be discharged for something like this. It's hard to get good ones. Not hard to get good ones. We put a lot of time and effort into securing good people. We love our faculty. They are the reason we exist. Really, the school is the faculty in many ways. So no, I don't see any retaliatory thing on the horizon. Okay.
Thanks very much.
Thank you for your time.
Okay. Is there any further testimony to be provided? Okay. It's 12:25, and we're going to suspend the hearing for now. The hearing will be reopened if additional folks come forward to testify. Thank you very much, everyone, for coming, for sharing your thoughts. It's 1 p.m. on May 26th, and this will mark May 22nd, and this will mark the end of the earned sick time hearing in Framingham, Massachusetts.